Welcome to my channel, All for Health with Jane. Family, we are still on the Senzo Meyiwa trial. After a long discussion and arguments by Advocate Mnisi, insisting that Brigadier Gininda must read out facts from the memorandum that he presented to the DPP, the memorandum that he presented to the NPA, that led to the NPA charging Mnisi. Advocate Mnisi insisted. And after that long discussion, Judge Rata had to allow Brigadier Gininda to read out those reasons, to read out those facts that are forming the base of accused number one being arrested. Family, let's watch and listen.
Thank you, Brigadier. I said I'm requesting the facts that you presented to the Office of the Director of Public Prosecutions, on which you are requesting them to make a decision on these accused persons. Thank you. You say, in respect of accused number one, you had evidence of a confession, you had evidence of a pointing out, you took statements from witnesses, and what else?
My Lord, so with greatest respect, previously, even on the trial, within trial, and subsequently on the trial, when I was busy, particularly under cross-examination, I dealt with the evidence that connects all the accused. And that is found because I was referred to various statements, but the statement which contains the facts, the evidence that I have on each of the accused, I was made to read it in court, and it summarizes all the evidence, and that is A198. That is the application for the warrant of arrest of accused, dated the 23rd of October 2020. Under each accused, the facts, as Advocate Mnisi says, it needs the facts of what evidence did I have. That is a summary of it, although I was directing it to the courts, but it was emanating from the docket, not from me, and it is the facts that I presented to the DPP. Now, if I have to be specific as to point by point what is contained, it means I must go through this statement. I've dealt with it. Go through it again. Okay, my Lord, it reads as follows. I, the undersigned, Bongani Nicholas Gininda, state under oath as follows. I'm employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same Act. I am currently stationed at the National Commissioner's Office as the commander of the Cold Case Investigation Unit at the National Commissioner's Office with the rank of a colonel. And then it mentions the service number as well as my cell phone number, my Lord. Paragraph 2 reads as follows. I'm the lead investigating officer of Phosphorus case 636 of 10/2014, which is a case of murder where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 2030 and 2100 hours. The deceased was shot at the house belonging to then his girlfriend, namely Kelly Kumalo. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that two black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witness stated that one of the accused was carrying a firearm purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second accused. The second suspect was described as taller, slender, neatly shaven, and dark in complexion. It is stated under oath that during the robbery in the said house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gunshots hit the deceased Senzo Meyiwa on close range on his chest and exited at the back of his body. The second accused focused on the rest of the witnesses. In the process, one cellular phone belonging to Ms. Kelly Kumalo was robbed by the suspect during the committal of the offense. It is also stated under oath that suspicious suspects were wearing it is also stated that suspicious suspects wearing specific clothing, amongst others a hoodie, were standing hidden away only few meters from the crime scene prior to the incident taking place, and on their cell phones. It is stated that the suspect fled on foot. The suspects fled on foot, and the hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspect hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identikits were compiled through witnesses of these suspects. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 20:30 and 2100 hours. The deceased was declared dead on arrival at the hospital on 21:15. Paragraph 3. Investigation revealed that the cell phone which was robbed was picked up through a cell phone towers until the signal was lost, covering the area of Phosphorus area. The said cell phone was never recovered to date or even switched on again. The evidence explained hereunder will indicate that the planning of the offense and gathering after incident took place at Phosphorus Hostel. Investigations which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than the robbery or robbery gone wrong. Evidence under oath revealed that 5 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa.
Thank you, hold it there.
Please, let him finish. You asked the question, let him finish.
But my lord, I'm busy taking note as well.
Yeah, but he must say what he said in that affidavit.
But then when I'm going to take
You've got a
notes,
copy, Mr. Mnisi. You don't have a copy of that affidavit.
I don't have it before me.
Okay, I'll adjourn. Please make a copy for Mr. Mnisi.
Thank you.
Okay. You may proceed reading that document.
Yes, my lord. So it says the suspects are as follows. 3.1, Mzika Ukulelwa Stemba Sibiya. He was first linked to this offense by means of witness statements under oath. The accused boasted to individuals closely associated with him in KZN homelands as to his involvement together with Mafika here under suspect 2, Carlos here under suspect 3, Mapisa here under suspect 4, and Kani here under suspect 5 into the killing of the deceased. A dispute ensued between these individuals, and the closely associated individual disclosed to the SAPS the admissions the accused made to them. The accused was further linked with circumstantial evidence wherein he, minutes after the incident took place, made disclosures. The incident made disclosures and remarks at a family gathering he attended in Phosphorus as to the killing of Senzo, even before the death was reported to the media. He is further linked by means of a formal confession he made to the commissioned independent police officer on the 30th of May 2020. The suspect further made a formal pointing out to the sequence prior to the incident, the guarding of the outside of the house during the assassination, and the dropping off of the accused at the cell phone tower referred to here above. The pointing out was made to another commissioned officer on the 6th of June 2020. The correct date, my lord, should be the 5th. That's when the pointing out was done. I just want to correct this, but I say it says the 6th. 3.2, Bongani Sandisontanzi, nickname Mafika. He is linked to this offense by means of certified sworn statement he made to the witnesses and an identikit compiled through the description of witnesses. He was identified as the person with a hoodie who initially stood outside of the house prior to the incident and running away after the incident. The involvement of this suspect was mentioned by suspect 1 here in above as equally involved in the killing of the deceased to the family of suspect 1. The suspect was traced through information received and he was confronted with the above evidence available against him. He was amongst others confronted with the clothes he was alleged to have worn and compiled identikit. During the questioning and subsequent search of the premises were ammunition found for which no license was produced. The suspect was arrested for this offense. Hereafter, the suspect indicated his eagerness to confess as to the involvement in this matter. The suspect made a confession to a commissioned officer on the 19th of June 2020 and later made a further confession in the presence of his attorney to a magistrate in Boksburg Magistrate Court on the 24th of June 2020. Through the confession, does it appear that this suspect is the suspect that was described as tall, slender built, which came into the house. 3.3, Ntobisi Prince, nickname Carlos. He is linked by means of a sworn certified statement in the docket referred to herein above. The involvement of this accused was equally explained in detail in the confession by suspect 2 above. Through investigation of this information contained in the confession, further evidence under oath was obtained as to the suspect's real name depicted above. It was established that the suspect was a sentenced prisoner serving 35 years in prison for murder committed in 2015. Ballistic tests revealed that the same firearm used in the murder for which the accused was serving his sentence were used in the murder of Senzo Meyiwa. Upon the accused's arrest in 2015, upon the accused's arrest for the 2015 convicted murder, a cell phone was seized in his possession. The cell phone downloadings of his phone were done. The photos found on his cell phone memory showed him wearing the same clothing that were identified by witnesses on the day of the incident as to the accused carrying the revolver upon entering the house. Photos downloads taken of the accused by himself, selfies, matched the description of the suspect who had the firearm with red locks, big eyes, and with the gold teeth. This is the suspect that went into the house, made a demand of cell phone and money. He is also the same suspect that shot the deceased in this matter during the struggle with him. Photos were equally found of the murder weapon used in the murder of Senzo Meyiwa. 3.4, Mthokoziseni Zipozonke Mapisa, also known as Mapisa. The suspect is linked to this offense by means of certified sworn statement referred to herein above. He is further linked by means of confession he made to a private person, open bracket, a close friend, close bracket, about his involvement in this matter. The confession came about in that this suspect requested this private person to establish the reasons why suspect Mafika was arrested. The information disclosed was that the suspect Mafika was not only arrested for ammunition but also for the Meyiwa murder. Upon the private person return disclosing this information to suspect Mapisa, did Mapisa instruct the private person to return to and inform suspect Mafika not to disclose his, that is now Mapisa, his involvement, as he, Mafika, will be assassinated. It was during this discussion that the suspect Mapisa confessed to the private person his involvement in the matter. Investigation revealed that the role of this suspect was to guard any unexpected people who may come in or outside the house. He was also armed with a small firearm. 3.5 Sifokuhle Nkani Ntuli, also known as Nkani. The suspect is linked by means of a sworn statement by witnesses referred to above. He is linked to a car that was used as a getaway vehicle, which is a silver VW Polo. Evidence also revealed that he drove the car with the suspect to the crime scene and back to Phosphorus Hostel after the incident. His role was to remain and guard the vehicle, guard the getaway car during the commission of the offense. The confession of Mafika, insofar as the usage of the vehicle refers to, is supported by independent witnesses confirming that this accused was seen driving the said vehicle prior to and after the committal of the murder in the company of the referred suspects above. The above suspects are also known to be hitmen for taxi wars. The said suspects were traced and found on different locations and occasions where they were warned according to their constitutional rights in terms of Section 35, Act 108 of 1996 by me, and questioned for this incident. Some of the suspects made confession to independent commissioned police officers as well as magistrates as indicated above. Others made confession as they were showing off to private persons who were well known to them after the incident, but on different occasions as well. Paragraph 4. Evidence by means of sworn corroborating and independent witness statement establishes a causal link between the offenders and the offense of murder, robbery with aggravating circumstances, possession of unlicensed firearm, and the unlawful possession of ammunition. The Director of Public Prosecutions, Gauteng Division, on a directive of the National Director of Public Prosecutions, instructed, after careful consideration of the presented evidence, that the above 5 suspects in paragraph 3 must be arraigned for murder, robbery, and with aggravating circumstances, as well as possession of unlicensed firearm and ammunition. The instructions are attached with this statement as BNG1. I hereby apply for the warrant of arrest for the following suspect as indicated, suspects on above indicated charges on this paragraph. Then the name of accused 1 up to 5 is mentioned, my lord. And then paragraph 5 is really an oath where I then place my signature, and then this statement was then commissioned on the 23rd of October 2020 at 100 hours by Sergeant Mohula. Then the BNG1 that I referred to, my lord, it's a document from the National Prosecution Services, Director of Public Prosecution, Gauteng Division, Pretoria. That's what it says. And there's a reference number 10 of 1/12/1-P243/2019, and the date is 21 October 2020. Then it says Senior Prosecutor, Private Bag, Box Bag 41460. The State versus M. Sibia and others, Phosphorus Case 636 of 10/2014. Then it reads as follows. The Director of Public Prosecutions remarks as follows. 1. In terms of Section 75 of Act 51 of 1977, I have decided to arraign the accused Muziga Ukulela Stemba Sibia at Muzindo, Bongane Sandison Tanzi at Mafiga, Mtobisi Prince Mngube at Carlos, Mthokoziseni Mapisa, Sifokuhle Nkani Ntuli Sifiso at Nkani, in the High Court on the following charges. 1.1 Murder, read with provisions of Section 51, open bracket 1, close bracket, Act 105 of 1997. 1.2 Robbery with aggravating circumstances as set defined in section 1 Act 1 of 1977, read with section 51 of 1 Act 105 of 1997. 1.3 Contravention of section 3 Act 60 of 2000, open bracket, possession of firearm. 1.4 Contravention of section 90 Act 60 of 2000, and that is possession of ammunition. Paragraph 2, you must request the magistrate to refer the accused for trial in the High Court on the said charges. 3, the magistrate must be requested to obtain the following information from the accused and to record it. 3.1, whether they will arrange for their defense or whether they want legal aid defense. 3.2, whether they want the state to subpoena any witnesses on their behalf. If so, the names and addresses of such witnesses must be furnished. Paragraph 4, if the accused are to be pleased if the accused are to be released, beg your pardon, my lord, if the accused are to be released on bail or have been released, the magistrate must be requested to include the condition referred to in section 52 subsection D of Act 51 of 1977, and to enclose the record accordingly, and to endorse, beg your pardon, and to endorse the record accordingly. 5, the following document is prescribed by section 144 subsection 3 of Act 51 of 1977 in terms of section 144 subsection 1A and 2 of Act 51 of 1977 will follow. Notice of trial, indictment of accused, summary of substantial facts, list of witnesses. The magistrate must be requested to endorse the service of the above paper, the service of the above papers, section D of Act 51 of 1977. The National Director of Public Prosecution has transferred the case to this office jurisdictional area as per the attached letter. Then it's a signature, my lord, of from the DPP, and that's the end of the statement, my lord.
Yeah, just for my knowledge, when this matter started,
Yes, my lord.
it was at Boxbeck, you say.
That is correct, my lord.
Any of the accused, did they bring an application to quash the charges because these charges don't contain any due process regarding whether they have in fact contravened the law?
I'm not aware, my lord.
No application for quashing?
No, I'm not aware of such, my lord.
Okay, fine.
You know, family, what Brigadier Gininda has presented here is a summary of this case. You know, if we have forgotten any details about this case, what Brigadier Gininda has presented is giving us answers to everything that has to do with this case. Another thing that makes me become more interested in this, it's Judge Rata's closing remark. After Gininda has presented, Judge Rata is asking Brigadier Gininda, is there anyone from these 5 accused persons, including maybe their defense, anyone who has quashed this statement, anyone who said, I do not believe in what Gininda has said now, has read out to this court. Anyone who said the information that Gininda has read out to the court is invalid. Anyone who has rejected and has done that in a form of writing. He says, did you receive any application that is quashing this information that you are giving to the court. And Gininda said, according to my knowledge, no one has done that. So by law, it means that the 5 accused were supposed to apply immediately when this case is presented to them. When they say they are declaring not guilty to this, so they were supposed to apply to quash, to reject this information and declare it as invalid. So family, hence I'm saying I'm a little concerned about this. Maybe those who understand how law operates in the comment section, let's talk about this. Give me your understanding and let's discuss this, family. But anyway, for now, thank you very much for watching this video to the end. Please like it before you leave. Subscribe for my channel if you haven't done so yet. I love you, family. Thank you. Bye.